5, 4, 3, 2, 1. We are live now.
Good evening and warm welcome to the 12th session of Story to Tell. The topic for the today's session is very unique, and the topic is ensure seamless transmission of your wealth to the designated beneficiary. The question which a lot of people ask that why we need to have such a topic. The reason I will explain in a very simple word. In life, there are a lot of uncertainty. But there is only one thing which is certain, and that is we are all going to die. We work very hard to build our wealth during our lifetime. But we all know that we are not going to carry a single pie with us. We are going to leave this world empty-handed. Most of us wish to transfer our wealth to our children or grandchildren. Some people may not have a keen relatives, and in that case, they want to give away their property or the fund to the people who have supported them during their life. A small number of people, they want to give their asset to the charity. We want this process to take place smoothly and without hassles, without obstacles. This is particularly important for people whose son or daughter are staying in other cities or out of India because they cannot visit to India or to the town time and again. But I am sure that all of us know many instances where the transfer does not take place that smoothly. I would like to share one incident like one of my friend, the two daughters, two sisters. The one sister stays in USA and another in Netherlands. Their parents died in a very short time. And after the death of parents, they wanted to transfer their property to their name. They decided to spend 10 days after the death of mother in the Ahmedabad so that they can complete the formality. And when they left, they were under the impression that everything has been done really well. And in the few days' time, the process will be over. After 6 months, they realized that it is not easy to transfer the asset. And one of the sisters has to come from Netherlands to India. So think about the constraint, think about the difficulties, the inconvenience the family has to undergo for such a simple thing. And that is a reason and that is the aim we really want to have this session. We are really fortunate that we have our expert on the topic with us today as a speaker. And he is Mr. Rajat Dutt. I will give a short introduction about Rajat. Rajat is a founder of Inheritance Needs Service. That's the company. I would think that probably the first of its kind of company in India, which provides a counseling related to succession and legacy. Before he initiated this company, he had 3 decades of experience in different sectors like banking, finance, and legal. And in those fields, he worked as in a diverse role and in a different positions. So he has an excellent background, which is very important for the topic. And today, in the initial part, he is going to tell us how to make a will. And after that, we will have a session open for interaction. And during that, we will discuss all the important questions, which are very important for all of us to understand. With that short words, now I hand over to Rajat for his lecture and then interaction. Over to you, Rajat. Thank you.
Good evening, ladies and gentlemen. Thank you, Dr. Ganjwala, for all the effort that you have taken to bring me today at this forum. I must indeed thank you for spending time on a weekend to understand this process. Let me first take you to the declarations and disclosures. The objective of this presentation is purely create awareness and to share knowledge. And hence we have assumed certain circumstances for you to enable, understand, and explain the relevance of various statutes and how they apply to real life situations. We have referred to many case studies to make it more interesting and portray the indicative scenarios which may or may not happen, but will surely generate academic interest. This in no way is diluting any of my clients' confidentiality, as I have signed confidential agreement, and in no way is their cases referred here. Photographs and pictorial illustrations are only representative in nature and form. So let me start this presentation with a big question mark. Do you know who you are? Well, yes, you should know, because you are born in a family. You were born to your parents, Mr. and Mrs., and you were born to your brother and sisters. And that's why you have a family name and hence a surname. So, birth creates eligibility for inheritance, and death triggers inheritance. However, there are two exceptions. The first exception being when a child is adopted under the Indian Adoption Act and the child comes into the family, then the child becomes eligible for inheritance, though not born to biological parents. Similarly, in the Indian environment, a lady, when she gets married to another family, that is a husband's family, because of her marriage, she becomes in charge of inheritance of her husband and so on and so forth. So, no one is immortal. You all know. I think Dr. Ganjwala has rightly said. Second, life is uncertain, but death is surely certain. Most important, you can't afford to leave anything to chance. And logically, there is no yes or maybe. You need to know all these things are facts of life and the reality. Of course, these pictures will tell you that age has no bearing. Except Satish Kaushik, everybody was a gymmer and took great care of their health. And unfortunately, all of the three, except Satish Kaushik, died in the gym itself. You are doctors and people from various other fields, so you know this better, and it was well advertised. Let me tell you, you are a parent, you have parents or parents in law, and you have siblings. And this is how an Indian family is. If you look at this family, please try to portray yourself where you have a parent yourself or you are a parent in law and you have parents and you have siblings. Each one of this, if you try to find out, they have played a very critical role in the entire life cycle. If you look at your parents, who could be baby boomers or Generation S, as we call them, they would have been born somewhere close to World War II. They would have spent every money to save, given you very good education, and also taken care of their siblings in terms of setting up a profession, vocation, or their marriage, and also saved money to be able to build a small house. And this house was built for having a roof over their head when they retire. They had no much aims and ambitions in life, and you, as their children, would have gone on vacations to only your Nana Nani's house, and that's about it. Take two, you become Generation X, born between 1960 and late 70s. In that, you were given very good education by your parents, so you got very good place in the profession, vocation, or into your service, and you got made good money through ESOPs or all the instruments you had for investment, which could vary from a mutual fund to a real estate or to gold bonds or even to a debt or to even equities. And you brought your standard of living high. Of course, you made the sole intention to get good education to your children, and maybe you have sent your children abroad at an undergraduate level. You now go on vacations, not only domestically, but maybe twice or thrice a year to international destinations. And you saved money not only to build one house, probably you also built another house because you wanted rental income to be your source of income and asset class, and you saved a lot of money. Now, if you're a Generation X, which is born between 1960 and 70, it is your responsibility that your parents are inheritance compliant, and it is also your responsibility that you become compliant. Why? Because your children, the two toddlers that you're seeing here, they are actually backpackers. They believe in investments and no saving or expenditure and consumption, and they are not worried about your inheritance or taking money from you post your demise. Now, following are the concerns which needs to be addressed. What will happen to my wealth after me? Who will get what from my wealth after me? How will the beneficiaries secure their portion of wealth? What has to be done now and post my demise? Who will do what now and when my demise happens? These are genuine concerns which may be giving you nightmares. Now we will address each of them together. These are concerns if you are an Indian resident in Indian, but think of the NRIs. NRIs have no track record of the Indian assets since they left the country. It is a big concern for him and highly pronounced. He will say that I have no supporting documents because I had left everything here and currently none of them are available. I have not disclosed of my assets to the tax administration in my domicile country. My relationships inter se and intra se with my family is not too great because I have been abroad. And the wealth transfer overseas while alive or post demise is a big issue which I need to address. So, statutes govern legacy. You must understand that now everything is in black and white, and the document process asset wise needs to be followed, and there is practically no scope for any interpretation. And testimony document or will or a trust is becoming a critical document and a must. If you don't have a will, then what happens is then the laws applicable on your birth applies. So for Hindus, Jains, Buddhists, and Sikhs is the Hindu Succession Act. For Muslims who are born as Muslims, it is the Muslim personal law, which could be either Sharia or as per the Aga Khan Khoja community, or for others, the Indian Succession Act, which is Parsis, Christian, Jews, or those married under Special Marriages Act. We normally get such questions in a conference or an e-meet. Why, at what age should I make a will? At what net worth should I make a will and is it relevant? They also tell, but I have assets in my joint names and nothing to worry. Additionally, I have nominations also registered. So why should I make a will? So I am now going to tell you the other side of the question as well. They also tell us that I am unmarried or a spinster or divorced. So why should I bother? They tell us we are happily married couple with either no children or only single child or maybe two educated children who are well settled and they will not fight. They also tell us that I am a widow or a widower with the same configuration. Some say that I and my spouse have only one house with financial assets of only 50 lakhs. Why should I worry of making a will? Now I'm going to put you some startling facts. Are you aware that appointing a nominee through a nomination form means only a nominee in a bank account does not have the rights of a legal heir? I must tell you that the bank will pay the money to the nominee because the person is a registered nominee, but he is not a legal heir. Secondly, a nominee in a life insurance policy is only a trustee of the proceeds that he gets from the insurance company. In case of a mutual fund, nominee is a sheer custodian who has to distribute the amount to the legal heirs. In case of a demat account, a nominee superimposes the nomination rules and becomes an interim owner for a very short period till the heirs come and stake their claim. The worst is that in a cooperative society, nominee is a custodian of the heirs and not the beneficiaries of the owner. Normally, people misguide and say that a share certificate in a cooperative society, if it is transferred in their name, that means they have become owners. Totally wrong. You have to become owner through a process which is through a registration in the sub-registrar's office. One more startling fact which most of you would have not known. I thought it is time that I bring to your notice. Did you know that in case of bank fixed deposit, if the fixed deposit is in joint names of a husband and wife, that is self and spouse, then under the either or survivor clause or any one of survivor clause, if you want to prematurely withdraw, then both the fixed deposit holder signature is required. In case one of your partners of the husband and wife is in the ICU, then one signature will not be able to withdraw the deposit in case of premature. You must also know that if one of them dies, then the joint holder cannot withdraw the deposit because they will have to wait for the tenure to complete. Premature withdrawal in either or survival clause of a fixed deposit is not allowed to premature with one signature, though you have supported your application with death certificate of the deceased joint holder. You can refer this, Google this, and you will find my article in Money Control, which has been applauded by very many people, including Reserve Bank of India. So, what are the challenges faced by a bereaved family? If I tell you the challenges post demise, the family is virtually under stress, handling a situation because of the sudden gap or a void, as we call it. We will find that the priority of the family, the residual family, is to immediately get cash flow requirements in case the bread earner has died. Most important, the transfer of assets from those owned by the asset owner who is now deceased to that of the owner of the family or the kin or the heirs is legally process driven, legally embedded, and time consuming. Also, the stringent laws and established procedures are placed. As I mentioned above, there is no scope for interpretation at all. If you have this, then this is the answer. If this is the situation, then that is the answer. Furthermore, the facts is startling and the reality is horrifying. Sometimes people and the family, the condition the assets are, they have to beg, borrow from their relatives to survive till the time they put everything in place. What we have noticed is when a person dies in the family, the spouse does not know where the investments are or the wealth are. If the spouse knows where the investment and wealth are, they do not know in what condition the documentation is, whether the documentation is proper to move to the next beneficiary or the heir. If they know both, then they do not know how to do that. So, in any case, they are into deep trouble and they are normally fleeced by people. While everybody knows how to make a will, I'll go into certain critical points which are very important for making a will. What is will? Will is actually a wish list which says that I, as owner of these assets, when I die, I want to distribute it to the following people in this particular form or format. So, will, I can say, is made by persons only over 18 years old who is the legal capacity to make a will. Also, he should be of sound mind and not be under threat or any coercion. Will must be mentioned that it is his last will and superseding any earlier wills. If he has made a will in 2022 and today is 2022, he makes a new will, he can write that this is my last will and give a reference of the earlier will which he has made in 2022 and say this will is replacing that earlier will. He may also say that only few paragraphs of that will is getting replaced, all the rest of the paragraphs continues as that. It is his choice and option. Will has to be dated and it has to be attested by two witnesses. It is very important who the witnesses are. Beneficiaries under a will or the spouses of beneficiaries under the will cannot be witnesses. What is bluntly said that the witness cannot have economic interest in any format on the execution of the will. Also, a will must be signed by the testator with a left hand impression is valid because sometimes people are not educated. They cannot make their own signatures. So, even a left hand thumb impression is valid. Also, a will must have the name of an executor or more executors because that executor may die and you have to have a replacement. So, a will with two or three executors is an ideal will. A will need to be registered or not is only the wish of the testator. To register a will, the competent authority is the Register of Assurances or sub-registrar's office, or in smaller towns is the district tahsildar office or the testator who resides, and is to be situated where the testator resides. More important, will should include all assets across various states of India. So if you have assets in Madhya Pradesh, Rajasthan, Gujarat, Assam, and also Tamil Nadu, you can make a will in any one place, including the assets, all other states of India. But if you have assets in the United States of America or in UK, then you should make a will in the domestic state country in which the assets are housed. But for Indian assets, you should have a different will. International assets would require testament documents as per laws of their respective jurisdiction. There are some intricacies on will. Will contains not only assets but also loans and debts. So, would a beneficiary be liable to pay the debts of a testator? I would like to give you an example. If my father had made a will and said that I will be getting this house and there is a HDFC loan on that house, then I will not have to repay the HDFC loan. HDFC will sell that property, take back its outstanding, and the balance portion comes to me. That's how it is. Role of witness is extremely critical. Witness may or may not outlive the testator, and that is why you must keep people who are from a legitimate background and who can be traced. Even if they die, they should be knowing that the witness has died, because that's very important when you need to take a probate. Role of executors, there is responsibility embedded but laced with authority. So the role of an executor is very, very critical. In many cases, people want to make their friends as executors. In front of the testator, they say, I would be an executor. But when the event happens, they are not traceable by the family. Or they say, no, by force, I was able made to give my name, but I'm not interested. That puts a big problem into the beneficiary's face. Second, if a testator does not want to give part of any asset to a particular family member, then testator must clearly mention in the name of the non-recipient. I have two children, but one daughter I want to give nothing, and the son I want to give everything. I must mention that in my this thing, I have two children, one son and one daughter, but I don't want to give anything to my daughter. I do not have to mention why I don't want to give. Second, a residual clause in the will is necessary because you may make a will in 2023 and you may die in 2040. So any change in the assets, change in asset configuration, change in type of investments, change in the name of beneficiaries will be taken care through the residual clause. In case of pastors and Christians, if the marriage of the testator automatically revokes previous wills. If there are pastors and Christians who are listening, then if they get married, they have to change and make a new will. I would like to brief you that shortcuts in making a will is an extremely expensive proposition. Will in most cases is used as a repository. When I use the word repository, means it has all the information of assets and prospective liabilities to enable the executors to find the assets and also pay off the legitimate dues as and when they arise. So will drafting is extremely critical because it is the only document which has no reference point, because the person who has made the will is no longer eligible for a dialogue or asking why you wrote this. Secondly, the cost of making a will is the least one should be bothered about, because the cost of not making the will is so expensive and highly stressful for the family of the deceased. Hence, you should not worry so much about the cost of making a will. Choice of the executors is the extremely critical decision in making a will. This is the common question. People are confused most of the time. Why is registration needed, or is registration really needed? Well, will is a supreme document and would override all the nominations. And what is more important to know is that they, irrespective of nominations governing any individual asset, the will overcast that. Second, a registered will is not compulsory. Many prefer registering their wills. Now, why do they do that? Because testators are guided by a standard tick box approach to decide will registration. They say that only if I have so much of property, I should register it. Only if I have these assets, I should register it. But the fact of matter is that registration of a will makes that you are making the government of Gujarat, or if you're registering the will in Madhya Pradesh, government of Madhya Pradesh a witness to your will. So that provides some comfort in case the will is challenged. Why register will? If movable assets are in Bombay, Kolkata, or Chennai, you need to take a probate, for which, if your will is registered, it is advisable. A probate is, what is a probate? A probate is a certified court process which signs that this will is the valid will and this will should be used for distribution of assets. I must tell you here that the probate, the process takes anywhere between 6 months to 12 months, depending upon the city where you are applying. But a probate does not look at contents of the will. It only looks at the technicalities of whether the will is genuine or the last will or the recent will before the deceased died. So probate does not in any manner comment on the contents of the will. So why is this noise all about? Will. So will is the only document which has a bearing on the will distribution of the testator. Any mistake in his drafting, recording ownership can pose a huge challenge during execution. Third and most important, bereaved family would need to make huge efforts to retrieve the wealth, which is actually their own, because their parents or the testator had worked very hard to create the wealth, which logically should go to them. Hence, instead of efforts would be more and the cost would be high. So, I need to say that treat inheritance as a social responsibility. Each of you here would have parents, each of you would have children, and each of you would have siblings. What I suggest is that you should address it, the issues of inheritance, ensure protection of earnings, and organize seamless transmission. I would like to take you through the film of Sid Gujarish, which talks of the living will. A living will is a medical advisory. It's a document which tells you that in case of a medical treatment wherein you are not in a position to take a decision, the living will guides your people known to you of how whether they should put a ventilator on you or they should plug off the ventilator. It also helps during a palliative care. So this has been extradited by our Honorable Supreme Court on 9th of March 2018. Recently in 2023, there was a litigation to challenge it, but they have not changed any rules and regulation and made it very stringent. I would like to take you through some case studies which are very interesting. Father, 4 children, 2 sons and 2 daughters, through a will, which was very sketchy, handwritten, had 1 witness signed and 1 witness only named. He wanted to give all his immovable property to 2 sons equally, while all the other assets were to be distributed equally under 4 children. Father died. The children went to the court for a probate because he was from Chennai, but the probate was not granted because the witness had not signed, the second witness, only his name was written, and hence it was proved that the will is not acceptable. It is flaw. There is a flaw in the will. So the father actually was treated as if died intestate. So the father was 50% owner with his wife on the property. So his 50% was shared equally with his wife and the 4 children. So 1/5 everybody got. His wife said, I will not create the same mistake. She made a proper will in which she said that my assets will be given the same formula, 2 sons equally in terms of immovable and the balance equally among the 4 children. Her will was perfect. When she died, they went for a probate. But look at the flaw. She could distribute only 1/5 of her share in the property to her 2 children equally, and only 1/5 of her share which she had received in the others equally among the 4 children. So this is the way the will is seen. Second, a husband mentions that after his death, the property goes to his wife, and after that it goes to his son. Husband died and the wife got all the property, but before the wife could die, the son died. And hence the daughter-in-law came and said, you transfer this property after your death to me. She said, it is my property now. I have all the choice to choose whom I should give. So that is how the will is. So the will made by the husband itself was flawed. Third one, a testator goes missing and is presumed to be dead after the Uttarakhand flood. Normally, the answer is that you have to wait for 7 years for the missing person till you come back. But in this case, the government of Uttarakhand, because there were so many people who were affected, allowed it for 2 years. And this gentleman popped up after 4 years back to Uttarakhand. And by the time they had already taken a death certificate and distributed all the assets among the beneficiaries. So the Supreme Court gave an order that whoever were the beneficiaries, they have to take care of the testator even till he is alive. Very interesting case. Mr. A, the first generation entrepreneur, married late in his life, and the age difference between his wife and him were 20 years. They had two sons in quick succession, a difference of 2 years. At age 62, Mr. A died, and he wrote in his will that everything should go to my died at age 64 years, everything should go to his wife. But the moment she marries, she has to be a widow all her life to enjoy the property. Moment she marries, it will not go. Unfortunately, the wife post demise had a live-in relation and met the obligations as per the will, but the children never got anything out of the will. Another case study, Mr. A was happily married to Mrs. A and had 3 children out of the wedlock, 2 daughters and a son in that order. Father of Mrs. A died suddenly without a will. She was the only child, so everything from the father came to the daughter, which is Mrs. A. But as luck would have it, Mrs. A died interstate within 4 months of her father's demise. Now you see, there was no action taken between the demise of the father. No legal procedure has started. So all the assets of Mrs. A's father was taken over by her uncles and aunts because there was no legal class 1 heir. So class 2 heirs took over everything, and Mr. A, the husband of Mrs. A, and the children got nothing. Daughters have equal birthright to inherit property. Honorable Supreme Court in August 11, 2020 have said, only in case of Hindu undivided family, the daughters will have equal right as the siblings if there is no division or if there is no will. My earnest request to all of you that it is all part of the family. I request it is all amongst us and close to us. Kindly be ready to make a testimony documents, a will or trust as you want to do it. I am open to question answers. Thank you so much for a patient hearing.
Yeah, thank you, Rajat, for excellent presentation. And you really confused us that what to do and how to proceed, because you gave us so many examples where the will, what we consider that this is reasonably good will, is not really effective will. So in that case, what are your suggestions how we should proceed?
Sir,
you showed us the problem, but what we are looking for is the solution. So
my question is, do not become a chat GPT to make your will. Do not download a standard will from the website and think that that's the right will for you. I suggest, and I made very clear, that cost of making a will is nothing that you should consider as against the cost of and the effort that will go by your family to retrieve your own wealth. So please make a will from reputed people whom you are comfortable with.
Okay, but only yesterday I was going through a net and I came across a website which guides you how to prepare a will. So they ask you a few questions and then they give you the format and they send you the document which you have to print. And then you have to get
precisely what I said. Chat GPT cannot bring out solution because every will is as per a situation. A family with husband, wife, and 2 children and an asset, the will of the husband will not be the same probably with another family who has again the same configuration and probably the same asset. The reason being is like in DNA, every will has to address a particular situation. So do not go by a chat GPT or a e-will portal because that may be very, very expensive proposition in the long run. Because there are people who are making wills for 400 rupees. There are people who are making wills for 900 rupees. There are people who are making wills for 4,500 rupees. People like us are making wills for 75,000 rupees. So you must understand that what is the cost of your asset. If you have a 5 crore asset or 2 crore asset, what is 75,000 as a percentage of that? If you have 50 lakh asset, 75,000 is 1.4%. So are you ready to take a call on making a will cheaper, but at the cost? Don't make a will just to meet a compliance. You make a will that it should be purposeful and it should help your family.
Okay, Dr. Sanjeev Bhai, you have asked a question in the chat. Can you unmute yourself and ask the question?
Yeah, good evening. Actually, my question is that if a court require witness to be present and witness are missing, or the witness himself has died, so what is the legality about the will itself?
If you are filing a probate for a will, and if the witness has died, the executor has to mention in the affidavit of probate that the witness is so and so and he has died, and attach his death certificate. In case the witness has died outside, not traceable, they should mention that we have made all efforts, witness was not traceable. That is why there are two witnesses used. So at least even one witness can say that yes, I was there when the other signed, but the other witness is not available. People normally make the people known to them as witness, so that nowadays we keep their mobile number, email ID, PAN card, Aadhaar card number in the witness itself. And that is why that is a court never asks a witness to be present. So if your lawyer is telling you the witness is to be present, he does not know the law. In any probate petition, a witness is not to be present, neither has the person petitioner to be present. He just has to file the registered papers with the wakalat number with the registry, and it goes on smooth control.
But sometimes what happens, very elderly people, they made the will and witnesses, even the children, they don't know who was the witness and where he has gone, means. And death certificates are also not traceable.
So in that case, the people who are beneficiaries will all join together and give indemnity that they all believe that the will is right, and all other, because when you file a petition, you have to give the family tree. In the family tree, if nobody has an objection, then they can have a consent affidavit signed by everybody, sir, and the witness's position gets normalized or gets sidetracked.
But sometimes family also have disputes, especially in property.
So then there is a problem. So if family has a dispute, there is surely a problem, and then it will go into litigation.
Okay. Yeah.
Okay, Prabir, can you ask your question? Okay, I will ask a question on behalf of Prabir. In the case of joint holder for FD, suppose Mr. and Mrs. A are joint holder and either of them dies, the surviving person cannot premature FD. That is what, like already you said. What about joint holding in the case of demat mutual fund in a similar scenario? To whom the fund goes?
First of all, I have spoken of FD because there is a special clause in FD. I will also tell you how to withdraw in such a cases. So first I will handle that. If you and your spouse are having a joint FD, tomorrow morning you go to your bank and give a letter saying that me and my spouse both have signed this letter. We have FD number 1234, which is in either our survivor. We are giving you a declaration in front of you and signing it that if any one of us dies, then the residual joint holder should be given permission to withdraw prematurely. You take the stamp of the concerned bank and attach it to your FD, and they will note it. If you have done this within the tenure of FD, and worst case scenario, any one of you dies, then you can prematurely withdraw. That's point number one. So that solves the situation. In case of two other assets, you mentioned one of demat account and the other one was of? Which was the other asset?
Mutual fund. The mutual
fund. Mutual fund laws and demat accounts are very clear. In case of a demat account, if there are joint holders, one joint holder has died, the surviving joint holder has to open a new demat account and everything gets transferred to that demat account. in that name itself. So Mr. A, B, and C are three joint holders in a demat account. Mr. B has died. So A and C has to open a new demat account in the order of A and C and not in the order of C and A. Make it A and C, and everything from the old demat account will get transferred to the new demat account, which is in the order of A and C. That is the law, and that is how you have to follow. In case of a mutual fund, if it is A, B, and C, and only C has died, then they have to go for transmission, in which the mutual fund will be transmitted in the name of A and B in that order.
Okay, the another question which has become very relevant nowadays, because government is asking to appoint nominees for everything. So what is the reason of like appointing
Sir,
a nominee?
1,82,000 crores is lying with the government of India for unclaimed. It is a big burden for the government to carry this and pay interest for people who don't know whom are going to come when. Hence, government is saying that this was done by so many years after independence. 1989-90, the act came. From there, it is 1,27,000 crores is lying. Now you better make all nominations clear, and hence, so that we don't want to accumulate this money and it's a headache for the government to manage. That is why it is said that you please make nominations important.
Okay, right. Yeah, Dr. Mustafa, please unmute yourself and ask a question.
Yeah, Rajat, the pleasure hearing you. If at all you recollect, I'm Mustafa Rangwala. We were
Of
together
course.
in Loyola.
Of
Yeah.
course.
It's very nice hearing you on this platform. I just had a question that, all the cooperative societies in this non-movable, immovable properties, they advise us to give nominations, and we do file nominations also. So according to you, I understand that there is no value of that nomination. Only the things mentioned in the will that which property should go to whom will carry that value.
So I think it's a very fantastic question, and let me give a full clarity to the audience here. A cooperative society is formed under the Cooperatives Act. How does a cooperative society work? There was a builder who bought a piece of land, or there was a developer who took over a land and developed a building or a structure on it under a development agreement. For that, he made you sign a sale deed or an agreement of sale, which you registered and paid the fees of registration and stamp, and you bought the flat number 101 with 1/15 of the common area as your land. That is registered with the sub-registrar's office per se. After all the people had come in, you applied to the Gujarat State Cooperatives Act, and you were given a registration number, and the society was formed. What is the society? Society is an administrative body with no legal powers. I repeat, society is an administrative body with no legal powers, only formed to administer and run the day-to-day maintenance and working of the society, means to pay the electricity bill, to give the sanitation, water tax, clear it, parking charges, etc., etc., etc. So, when they form this society, they need members. The members are the people who are the owners. So they contributed 500 rupees each or 1,000 rupees each, and they were issued share certificates. That was the corporate share capital of the society. After that, what typically happened was that this money was given in the times of share certificate. Now, share certificate is issued under Securities Contract Regulation Act, which is in the name of your husband and wife as the registration deed happens. Now, that is governed by Securities Contract Regulation Act, so you need a nomination by default. That is why every society wants you to have a nominee in that. When one of you dies, then they delete the name and they trigger the nominee and say, from now on, the share certificate is owned by the nominee, and I will be charging the new maintenance bill in the name of the nominee. So, Dr. Mustafa, the nominee is the owner of their share certificate, and their share certificate can only give possession and not ownership. For the ownership, he needs to go to the sub-registrar's office, show the will, or have a petty namu, so as to convert that in the name of the real owners or heirs, if there is a will through a probate, and then through a court order or a judicial order, convert the agreement from the name of Mr. A and B to the name of C and D, who are the children. So nomination only gives possession and not ownership. Ownership can be only decided by Transfer of Property Act. That is where it is registered in the sub-registrar's office. And most important, that the Transfer of Property Act applies to the asset, which is the building and the land. Securities contract regulation is only for that certificate. Have I made it clear, sir?
Yeah, definitely, Rajat. One another question which I wanted is that normally, FDs and all or DMATs are in joint account, but properties we don't normally hold in joint accounts. I mean, there are, husband's property or wife's property. So I think, is it a mistake? You should always have properties also in joint accounts.
So all the properties bought before 1970s were in single name. But if you have bought property after 1970 and taken any loan assistance from anybody, then whether it is HDFC or ICICI or whoever may be, they want a co-borrower, for which you by default make your wife or spouse or mother or sibling as a co-borrower. Hence, all the assets started going into the joint holder's name. That's point number one. Because no company or no bank or no NBFC will give loan to a single borrower, because they are not too sure what will happen to the only sole guy.
Borrower.
The second most important thing you must remember, that if you have paid all the money, and I want to tell you this because you should know about this, and if you are in the sale deed, you have mentioned the name of you and your wife, that means by default she has become a 50% owner. So if your wife divorces you, she will take that 50% ownership and she will tell the court that now from my husband's 50% ownership, you please give me and accord a decree to give me a share. So that 50% is hers, so you have paid the money, and now the balance 50% you have to give. For income tax purposes, whoever pays the money takes the advantage. So for income tax purposes, for the same property, because you have paid 100%, you take the income tax benefit. But though your wife for Transfer of Property Act is a 50% owner.
Okay. Thank you, boss. Thank you.
Pleasure.
Yeah. Dr. Aminakshi, madam, can you unmute yourself and ask your question regarding the medical leave?
So, good evening and thank you so much. It was an eye-opener for a lot of things that we took for granted. So my question is about this medical will. I've written a medical will that I don't want any interventions. I don't want any of those, life enhancing things. But then I have written it, I've sent it to my kids. But what if they don't actually use it? Because I will be sick.
Yeah, so it is actually a medical advisory. And the whole idea is that your children may be far away, may not know what happens. So you have to give it to the people who are close by and who will be close to you when something worse happens. People nowadays carry their medical advisory, or it is known as a living will. It is not a medical will. The technical term is a living will. So they carry a living will with them even if they are traveling, because if something happens, the living will from other papers, they will be in a position to find that. So living will is very stringent. As I told you at the start of the seminar, in case you want it to be vetted to us, I'll be too happy to vet it and tell you whether it's legal or not. You may share it offline because we have also given our email ID. I will vet it for you and tell you whether it's in proper order or not. Not a problem at all.
Okay. Dhiren Bhai, can you unmute yourself and ask question?
Good evening. My small question was, if FD is in joint name and the surviving member is beneficiary in the will also, then how the bank will treat it for premature?
So they will say, we don't know whether this will is the last will, so please get us the probate. So again, you're going to spend 6 months. Better you make that letter today, take both signatures and give it to the bank. That's the cheaper and faster way. Because even if you have made the beneficiary, your joint owner as a beneficiary, they will not depend on the will that you have given you. They will say, I want a legal certification that this is the last will.
Okay, but then in that case, FDs get renewed and sometimes change.
Don't worry, you can write. You don't have to write the FD number. You can say FDs with Union Bank of India, whatever bank you have, and say which is on a rotating or revolving basis, and this is valid till the date on the date all the FD is outstanding on date of my demise.
Okay, so it can be a generalized letter also, which works for future, FDs also.
That's right.
Okay, thank you.
Rajat, then there is a question by SSA. A hard copy of the will goes missing. Is a soft copy in the laptop is okay?
No. A will, when you're giving a probate, for a probate, or when you want to use, you must have the original will. The best way, if you register a will, and if your will is lost, or if your beneficiaries have torn the will, or if your wife has torn the will, then not wife, sorry, if your spouse has torn the will because he or she does not want it to go in a particular way after your death, then the family has a choice to get to the registrar and get a copy of the will, and that is a valid will as treated to be a original will.
Okay, yeah. Darshan Bhai, please unmute yourself and ask a question.
Doctor, I have a supplementary question on this.
Yeah, please, Dhiren Bhai first and then Darshan Bhai.
Okay, thank you. If will is registered and on a later date a new will is made, that also has to be registered to be valid?
No. The law is the last will is the final will, or the recent will is the final will. So if the first will was registered and the last will before 3 days of your dying, you have changed the will, if that is a legitimate will, then that will be accepted. It need not be registered.
Okay, thank you.
I must also tell you, you can register a will after your death. So if I have made a will today and not registered it and I die tomorrow, my children can register a will after my death. There is a clause in section 4041 of Indian Registration Act which allows the beneficiaries to register will post demise of the person who has written the will.
Thank you.
Yeah, Darshan Bhai, please.
My small question, can anybody transfer the residence equally to the two children?
Yes, of course.
How it is possible? When share certificate, how will you give the right?
No. So what typically happens, I think it's a very logical question. You have two children, both are equal in front of you. One stays in US and one stays in Ahmedabad. Now you want to give to both children. So the will should be so specific which mentions that I want to give the share of this house equally to both children, but my one child is not here and one child is staying here. So there is a formula. If my other child wants to buy off the other, then he has to pay him as market rate. If he wants to stay back, then he has to pay the market rate. If he wants to continue be as joint owners, then he should pay rent equal to half. He should, all these are things, you should make clarity on the will itself.
But suppose both are in USA.
Then you transfer in both name and they will be joint owners. No problem, sir.
Our share certificate, how will you put the two names?
Two names, Mr. A and Mr. B, joint owner. It is not that the first owner becomes the owner. The first and second are joint owners. Like you and your wife, both are equal shares, sir.
Right. On share certificate, we can mention
both up to 15 names. The law allows you to make up to 15 names.
Okay. Thank you.
Okay, then there is a question from Kalpesh. In case of joint PPF account in the name of Mr. A, the first holder, and Mrs. A, the second holder, and their son or a daughter is nominee, and either of holder dies, to whom shall the fund goes?
As you know, PPF account is a very tricky account. It was having joint ownership, but the name of the first person is always counted for income tax purposes. So if the first person has died, it normally is shared the second holder and transferred to the second and ceases to be a PPF account anymore. So they have to divide it at that time itself. Logically, it goes to the second owner, but the will can say it goes to half to my son and half to my wife. So the will supersede. And in case you know that nominee is only a stakeholder, he is not the owner.
Okay, then there is a question from Urmi. If person dies and nominee will get right of all the FDs, demat, mutual funds, and after some period of time, a legal head comes and asks for the ownership of all. If is he or she gets the ownership? Yes, I think you have already clarified that.
Yeah, I want to clarify this further. both in case of the FDs, bank accounts, demat and mutual fund. The Banking Regulation Act, the Depository Act, as well as the SEBI Act are very clear. Whosever name is the registered nominee, they will give to them and the account is closed. Whenever somebody else on the family says that I am the heir, he said, please go, we have given it to Mr. So-and-so, who is the registered nominee. Please go and talk to him, meet him, discuss it. If he does not pay, file a case against him. Our privity of contract ends with the nominee. That is why, as I mentioned that there are only two methods of transferring ownership post demise in globally. One is if there is a testimony document, yes, and the second is through act of law. So there is no nomination does not become into any way a succession of ownership. Nominee is only a stakeholder for temporary period.
Okay, then I have a question which is very pertinent, because time and again we see that problem. In the PAN card and the Aadhaar card, there is a mismatch in the name. What is the solution, or what is the problem? So both problem and the solution.
I will give you my problem and I'll give you my solution also. I myself am a real example for that. So my name in my apartment which I brought is Rajat Dutta. I made my PAN card in the name of Rajat T. Dutta, and then I made my Aadhaar card in the name of Rajat Tusharkant Dutta. When I die tomorrow, my wife will get the death certificate in the name of Rajat Tusharkant Dutta. And she will have a horrific time to tell that the guy who has died is Rajat Tusharkant Dutta, flat owner is Rajat Dutta, both are the same guys. This is his will. Please give that flat to me because he has told me to give it to him as a wife. So I will circumvent this. Either I make my PAN card and Aadhaar card as the same, but I cannot change my house name because that's very expensive proposition. But my will, I will mention that this will is of Mr. Rajat Dutta, also known as Rajat T. Dutta, also known as Rajat Tusharkant Dutta.
Okay, so that's the thing which you need to write in the first sentence of the will.
That's it.
Okay, good. Thank you very much for a wonderful suggestion. Then another thing which we have not discussed in this, but in a small number of cases, particularly when there is no legal heir, and the person wants to give the property to someone who is not blood related. In that case, what is a formula and what is a technique which one need to adopt?
Whenever such cases happen that he may have an heir or he may not have heir, or he may want to give it 100% to charity, he must make a testimony document, typically a will, to enable everything to be enforced by the executor so that it goes straight to the charitable purpose. Please note, if you say it should be given to some Gaushala, it should be given for the education of poor, these things are not valid and not accepted and not appreciated. You have to write, I want to give it to Anandji Kalyanji Trust, 20% of my estate. I want to give on donation to Vikram Sarabhai Memorial Hospital only for cornea operations for girl child, 10% of my wealth. You have to be very specific because that helps the executor to execute it properly. Otherwise, the executor is very confused. He may give it to whatever which you may not want to serve the purpose. I also want to make one thing very clear today in this, that globally, the death wish or the will or the testimony document of a disease is seen in very high esteem and respected very much.
Okay. Yeah, Mustafa, the last question, because we are coming to the end of the session.
Yeah. Actually, Rajat, I just wanted to know that the nominee is mentioned in the PPF accounts. Supposing the PPF account is a single name, then I think the bank will respect the nominees, or they will just take into account the will mentioned.
No. So, as I mentioned to you, the Banking Regulation Act is very clear. If they will not even touch your will. They don't want to touch your will because the moment you go to a bank with a will, you're making a biggest mistake. Because the moment you go there, he will say, I want to know get me the probated will, because I don't know whether this is the last will. So if there is a nominee, as I think Dr. Ganjwala said, everybody wants a nominee. The nominee will get the money, and then the nominee may be a person who is the beneficiary in the will or may not be, but nominee will get all the money.
So bank nominees carry a value, you
yes.
mean to say?
No, only hang on. bank carries, every nominee carries a value, but that is only a temporary parking. Ultimately, the
Okay.
heirs will get it as per the will or as per succession.
But as far as the will is concerned, the banking transactions will not be respected by the will, you said.
No, bank will not factor in your will because they don't know whether this is the
Exactly.
last will.
Okay.
So in a
Thank
very
you, boss. It was
different,
really
in a
great.
very different way, I'll give you a story. So there is one client who is a very reputed guy in Ahmedabad who shifted to Bombay, and his wife died and the children were abroad. So the servant made him sign during his last days, and the servant became a nominee in all his assets except house. So even he became, so when he died, before the children had come, he was serving the children, and the servant took all the money and went away. So after the bereavement, about 15-20 days, when they found out the nominee was the servant, so they traced him out, and the servant was filed a case, and he had to pass on everything to the family. He died without a will, but because there were two daughters and there was nobody else, they became the owners.
Okay.
Okay.
Thank
Yeah,
you.
Dhiren
Thank
Bhai,
you. It
your
was
last
really
question. Yeah, last question, and then we will end the session.
Oh, thank you. I think partly it is answered. If bank, transfers all the money in the name of the nominee, then he is eligible to use it, right?
No,
Right.
he is only a custodian. He cannot use it.
But how is it enforced? Because it is
Because
transferred.
the heirs will take him to court, no?
Okay.
Suppose you're giving it to suppose you made your servant a nominee, and when you die, the nominee takes over all the charge, and when you come, they will just put him to court and he has to pay every fine. He cannot use it. That is why a nominee in a cooperative society can rent it, but he cannot sell the flat. He can rent the flat because with that money he can maintain it. But he cannot sell the flat. Nobody will buy that flat.
Thank you.
Yeah, thank you, Mr. Rajat, for a wonderful session. And it was really eye-opening, and at the same time, really making us more watchful and really worried that we are making some mistakes and how to avoid those mistakes. I'm really very happy that you elaborated well on this very important topic. And what I will do is, like, I will share your number and email address to our group members. So if they want to consult you, they can get in touch with you and they can have your opinion. So thank you once again for sparing your time, and to our group members also for asking very important and particular questions. Thank you once again, and have a
Thank you
great
very
time.
much. Have a great evening. Thank you.
Yeah.
Bye-bye and good night.
Bye-bye.
Bye-bye.
Bye. Good night.
Stop video. मैं अब तुझसे ना समझू जब देखते हूँ ये इंटर कर बंद कर दो
રેકોર્ડ કરી નાખો
ના હવે આમાં રેકોર્ડ આ તો છે બધું તો જો મારે અમુક આવું અત્યારે ઇમ્પોર્ટન્ટ વસ્તુ જાણ્યું તને સમજાવું